Okay, we can go ahead and get started. It's 12:30, and I know that everybody's time is valuable and precious these days. Hello, and thank you for joining us for our very first webinar from the Office of Charitable Giving, Charitable Gift Planning, rather, sorry. I am Jessica Nottingham, Assistant Director of Plan Giving at ECU, and I'm happy to bring you this opportunity with Mr. Tim Prosser with TIAA Kaspick and our own resident gift planning expert, Mr. Greg Abiunis. Many of you may have worked with Greg already during your time with ECU. We're so glad you've joined us, and we hope that everyone is staying safe, healthy, and sane, or as sane as possible. As we get started, I wanted to share some quick housekeeping items with you. First, please know that this session is in webinar format, so you cannot hear or see yourself as an attendee. This might be a little bit different if you have used Zoom for a typical meeting format. Also, we have muted all of your lines until we reach the Q&A portion of our session, which is later on. And please keep your lines muted until we get to this portion. Some of you have already submitted questions through the RSVP page, and we hope to get to those, as many of those as possible, towards the end. Last, we are recording this session, so if you have to hop off early, no problem. You'll get a link to the recording. And many people might not be able to be here with us today, and they'll get this link as well. We are thankful for your patience and understanding as we navigate the ins and outs of technology. And without further ado, I'll hand it off to Greg Abiunis, Senior Vice Chancellor for Development here at ECU. Thank you.
Good afternoon. Our number one goal today is to continue to provide top-tier service with financial, tax, and estate information to our valued alumni and friends. Since this pandemic began, we have really focused at being a leader in communication and distribution of pertinent legislative and tax law information that can benefit you and your family. In continuing with this theme, today we have a 1-hour presentation with a 30-minute Q&A with a national leader in the field of estate planning and charitable giving. I'd be remiss if I did not mention that we have a partnership with the North Carolina Gift Planning LLC, giving us access to TIAA Kaspick that includes the opportunity at a very low expense to provide split interest gifts such as charitable gift annuities and charitable remainder trusts, as well as the ability to appropriately strategize about gifts of closely held stock such as family business succession planning that can be tied into gifting. Regardless of if a gift is extremely simple, such as a bequest provision or IRA beneficiary designation, to seeking income for life for you and your family, to looking at closely held business succession planning, we have the ability to walk you through all of these gift discussions that will help you reach your philanthropic goals for East Carolina University. As you have read and heard, our staff is willing, when safe again with COVID-19 protocols, to drive or fly anywhere at any time convenient with your schedule, including early mornings, nights, or weekends, to discuss your gift interests at ECU. In the meantime, we will gladly schedule a team, Zoom, or phone call to get those conversations started. It is my pleasure to introduce you to an outstanding professional and friend, Mr. Tim Prosser. Tim joined TIAA Kaspick in 2009 with nearly 20 years of experience in legal practice and financial services. Prior to joining TIAA Trust Company in 2000, Mr. Prosser practiced law in the areas of estate planning, estate and trust administration, charitable giving, and business succession planning with the firms of Sonneshan, Nath, and Rosenthal, as well as Armstrong, Teasdale, Schlafly, and Davis in St. Louis. Mr. Prosser served on the board of the National Association of Charitable Gift Planners and was chair of the CGP National Conference. He's a past board member and president of the St. Louis Plan Giving Council and a recipient of the Council's Founders Award. He is a frequent speaker on charitable and estate planning topics. Tim received his JD and MA degree in public administration from St. Louis University and his BA in Russian area studies from Loyola University in New Orleans. Tim, thanks for sharing your time and expertise with us today.
Hi, Greg. Thank you very much. It's my pleasure to be with everyone today virtually. I'm really happy to share today's discussion with you all because I think the information that we're going to discuss is important, and it's very useful, practical information for you to be thinking about as you plan your estates and as you manage your philanthropy, your charitable giving, whether that's to East Carolina or to other charities that you support. We're going to cover a variety of topics today. We're going to start off with some estate planning basics. It's certainly not meant to substitute for a conversation with your own estate planning attorney or tax advisor, but I do want to hit some key topics that I think will be useful for you to have in mind. Then I'd like to walk through a reminder of some recent legislation at the federal level that impacts us all as we think about our charitable planning and our estate planning. And then finally, we will shift gears and we'll talk about some charitable giving techniques that can also provide you with some additional income in retirement. I know that that's always a popular topic, and before it was mentioned that some questions came in through the RSVP page, and that was certainly a topic that at least a few of the attendees today are eager to learn about. So I'm super happy to share that information with you. I'm going now to share my screen so you can see the slides that we'll be walking through today. And as mentioned before, we're going to start today with a review of some estate planning basics. Again, not meant to be a substitute for a discussion with your own advisor concerning your own situation and your own goals, but this should be a good overview of some key topics. I thought a good place to start would be, how does property pass at death? You know, many of us think, well, gosh, I have a will, and that should pretty much take care of things upon my death. But it's important to know that the will only governs disposition of property that the decedent owns in his or her sole name at death. So if you have a home or a bank account or a car and it's titled only in your name, those types of assets will pass under the will. Of course, assets that pass by will do so through the probate process, which is a process in the probate court. In some jurisdictions, it goes by a different name. It might be the orphans court or something similar, but it's the probate court in the county and state where the decedent was domiciled at death. Or in the case of real estate, there could be an additional separate probate proceeding where the real estate is located. So if you have real estate in two different counties or in two different states, there could be two different probate proceedings at death. One solely to take care of that real estate that is located where you were not domiciled at death. So that's property passing by will, things that you own in your sole name at death. What about the revocable trust? Sometimes we call this a living trust. Many people will have a revocable trust as the principal document of their estate plan. And of course, the idea is to accomplish the same sorts of things that we would accomplish by the will, that is, getting property transferred to the individuals and charities that we want to benefit upon our death, but to do so outside of the probate process. Well, it's important to know that property only passes under the revocable trust if that property is titled in the name of the trust or in the name of the trustee. That property can also get into the trust upon death through the will. We'll talk about that in just a moment. But important to note that the revocable trust is a great way to pass property at death and to avoid probate, but it's only as good as our actions in getting property transferred to the trust. Other ways that property passes at death, by operation of law. You may have a piece of real estate or a bank account that's titled JTWROS, Joint Tenants with Rights of Survivorship. between you and someone else. What that means is that you own that property jointly, and at the death of the first joint tenant to die, the surviving joint tenant automatically owns that asset. So that passes by operation of law to the surviving joint tenant. Other ways of passing property by operation of law include transfer on death, TOD, or payable on death, POD. Titling, sometimes we see that with automobiles or with bank accounts. It doesn't create the same sort of joint tenancy that the JTWROS property does. Rather, you own that property during your life, but upon your death, it automatically passes to whoever you have named in the account titling instrument to receive it upon death. So if it's a bank account and you are Mary Smith, your bank account would be titled Mary Smith, TOD, East Carolina University, just for sake of example. Upon your death, that property would, that bank account would belong automatically by operation of law to East Carolina. Pretty simple way to avoid probate. Another operation of law, a type of transfer, I call a beneficiary deed. Sometimes it's called the transfer on death deed. I do not believe that North Carolina has this yet, but most states do. I think 38 of the 50 states have such a thing. This is essentially a TOD for real estate. It allows you to title your real estate, could be residential real estate or other real estate, to title it in your name, but to provide in the deed that upon your death, that real estate will pass to the beneficiary named. Again, another great way to avoid probate. I don't think it's available yet in North Carolina. I was just researching that yesterday, but in most states, it is available, and it would not surprise me if in the near future North Carolina created such a vehicle. Finally, another way that property passes at death that I think we're all familiar with is by contract. Most commonly, we see that with regard to retirement plan accounts like IRAs, 401ks, 403bs, where when you opened up your IRA account, one of the pieces of paper you had to complete was the beneficiary designation form that said where that money in the IRA goes should you die. Same thing with the 401k or the 403b. When you sat down with the HR department at the new job and you were filling out that stack of paperwork, part of what you were filling out was a beneficiary designation form for your 401k or your 403b account. Those are contractual documents. Doesn't matter what your will says. The will is not going to govern where your IRA goes. It's not going to govern where your 401k goes. The assets in those accounts are going to pass by beneficiary designation, which is essentially a contractual document. Same thing goes for life insurance. We know when we take out a policy of life insurance, one of the most important things that we're going to fill out as part of that application process is the beneficiary designation form that says who is going to receive those proceeds upon your death. Those assets, again, are passing by contract outside of probate. The will does not control where the IRA, 401k, or life insurance assets will go. So that's just a quick overview of the ways that property passes at death. One overarching consideration that I'd like you to take away from this slide is that it's really important to coordinate how your property is titled with your planning documents. A lot of people have sat down with their attorneys and put together wills and revocable trust instruments and spent some money doing that and some time, and then found, or perhaps their families found, that those documents weren't worth really much more than the paper they were printed on because their assets were going to pass in some other way, by operation of law or by beneficiary designation, for example. So very important to make sure, and this is an important part of estate planning, to make sure that if you have a revocable trust, that it's going to be funded, that you're going to retitle bank accounts or real estate or automobiles in the name of the trust. Or if it's a property that's going to pass by beneficiary designation, that your revocable trust is named as the beneficiary. If you want life insurance proceeds to land in your revocable trust at death, that happens by naming the trust on the beneficiary designation form. If it's property that you own in your sole name at death, but you'd really like it to pass under your trust, as we'll see in a moment, the will can also name the revocable trust as a beneficiary at death. That's a special kind of will called a pour-over will. The message I'd like you to take away from this, though, is that coordinating how your assets are titled and how they pass at death with your estate planning documents is an important part of the estate planning process. I've mentioned those estate planning documents a couple of times. I thought we should just take a quick look at what are the documents that comprise a typical estate plan for an individual. Normally, an individual will have a will, a revocable trust, and at least one power of attorney. Sometimes they're split into two powers of attorney, one for financial matters and one for healthcare matters. Let's take these documents one at a time. The will, which we've already talked about a bit on the previous slide, of course, governs disposition of assets that are owned by the decedent in their sole name. The will also provides for payment of debts, taxes, administration expenses by the executor. That's what it's called in North Carolina, I believe. Other states, it's called the personal representative. That's the person that you name to essentially manage your estate upon your death. And then that person is also responsible for collecting assets and distributing them according to the terms of your will. Again, the will takes effect through the probate process. So this is the court proceeding in the local probate court where the probate court is overseeing the work of the executor, where the executor has to file accountings and plans of disposition with the court and get the court's approval before those dispositions can be made. Probate is a public process, just like any pleading in any sort of lawsuit that's filed in court is public and anyone can come see it. Anyone can look at a will that has been filed for probate. So it's a public process as well. And it can be expensive. It can be time consuming. Another thing the will does, if you have minor children, is the will is typically the document that names the guardian for your minor children should both natural parents be deceased. So for some young folks who might otherwise not be thinking about estate planning, the fact that they now have children is sometimes the impetus for finding an estate planning lawyer, because they say, my goodness, we have young children. If something were to happen to both of us, we need to name the guardians for our kids. The revocable trust is, again, a document that can achieve the same dispositive effects as the will. It says where property goes and how it's to be administered for the people that receive it. It also provides for payment of debts, taxes, and administration expenses. But the person, or sometimes it's a bank or a trust company, that's handling the revocable trust and making those payments and distributions is called the trustee. And so in the trust instrument, you're going to name who is the successor trustee to manage your trust after your death. And again, property passing under the trust passes outside of the probate process. So we avoid public scrutiny and we avoid all of the expense and the extra time associated with the probate process when assets pass under the revocable trust. I mentioned before that sometimes there's coordination between the will and the revocable trust. Oftentimes, an individual will have a revocable trust as the main estate planning document, but they realize that it's possible I might have some assets at my death that are held in my sole name. I forgot to name my trustee as the owner of these assets, and I want to make sure they get to the trust. How is that done? It's done through the will. That's a will that's called a pour-over will. It's kind of a safety net for assets that the decedent owns in their sole name at death. It causes those assets to pour over at death into the revocable trust. So it doesn't avoid probate altogether, but it's typically a shorter probate proceeding to have those assets pass over to the revocable trust for distribution. A good estate plan is also going to try to avoid a trip to the probate court during life. And that's accomplished in a couple of ways. A financial durable power of attorney is a document that appoints an agent, sometimes called the attorney in fact, to manage the principal, that's you, to manage your financial and property matters in the event you become incapacitated or disabled. If you're in a position where you can no longer manage your affairs, your family would probably like to avoid a trip to the probate court to have a conservator appointed for you. And you can avoid that by having a financial durable power of attorney in place. That word durable, by the way, means that this document continues in effect, even though you have become incapacitated. That's its main purpose. Along with that financial durable power of attorney, you should have a healthcare directive. If you've gone to the hospital for a procedure, you've probably been asked whether you have such a document already. That healthcare directive might be called a healthcare power of attorney. Sometimes that's the name that it goes by. It appoints an agent, again, to make decisions for you if you are incapacitated or disabled. But these decisions aren't about your finances and property matters. Rather, they're about your healthcare and other personal matters. The impetus here again is to avoid a trip to the probate court. This time we're trying to avoid having a guardian appointed for you should you become incapacitated or disabled. And this healthcare directive typically will also include your wishes about end-of-life matters. Should an individual, be in a persistent vegetative state, the healthcare power of attorney will either provide what the individual's wishes are with respect to extraordinary measures that might be taken to prolong the dying process, or it might give the authority to make those decisions to the attorney in fact. That's a more flexible way to proceed, but it's really important then that the attorney in fact understands what would the principal want to have happen in that sort of situation. Greg, I think I will pause at this point and just ask if there have been any questions that have come in the chat or any earlier questions that you think are appropriate to this part of the talk.
All right. There have not, that I have seen, any questions come in thus far, but some of the previous questions, let me look, and there should be one or two that I think would be appropriate at this time. One of which is, do most people work with an attorney and bring their planning documents with them to make sure, as you were talking about, that everyone is in concert with what the total comprehensive plan is?
Yeah, I think that's a really good practice. If you have an estate plan already in place, maybe you have a will from a long time ago, and you've decided that it's time to brush that off and see whether it still accomplishes your goals. You'd want to bring your existing documents with you to meet your estate planning attorney. You'd also want to be thinking about what are all of my assets. That your attorney might not want to see recent statements from all of your bank accounts, but your attorney is going to want to know what kind of property you have and how it's titled and approximately what it's worth to see whether or not tax planning is an important part of your estate plan.
Sort of as a follow-up to that, Tim, I know you did this, as a profession for a number of years. Is it also helpful to perhaps bring in some of the other advisors, such as your financial planner or your accountant, that also have a good picture of your cumulative assets to, again, make sure everyone is on the same page?
Yes, Greg, that's kind of an ideal situation where the financial advisor or maybe the CPA is in touch with the estate planning attorney. Oftentimes, the financial advisor is the source of that information, at least on the financial side. They typically have the most up-to-date picture of all the assets that the individual owns and how they're titled, and if there are beneficiary designations, how those are currently made out. So, yeah, when I was in private practice, I loved to work closely with the financial advisor if possible.
Excellent. So that's a great thing for our people to think about and consider. I think the more information that the attorney is working with, the better the overall plan is for you and your family. Several of the other questions I think we'll come back to in a bit because they talk about life income things, and I know you're going to touch on that a bit as well. So I think this will be a good time to dive back into some of the possibilities that might be available down the line.
Okay. Well, the next item on the agenda, at least for the prepared comments, is kind of a legal and regulatory update, really more of a legal update. I'd like to take a quick look at some recent changes in federal law that impact all of us as we think about our estate planning and our charitable planning. Back at the end of 2017, it took effect in early 2018, was the Tax Cuts and Jobs, it should say Jobs with an S, Tax Cuts and Jobs Act, sorry. This was the tax act that was passed early in the current presidential administration. And we're all familiar with it, I think, on the income tax side, because it did make some significant changes to the income tax portions of the tax code. It reduced the corporate income tax rate dramatically. It doubled the standard deduction for people who don't itemize deductions on their income taxes. On the other hand, it reduced the ability for itemizers to claim deductions for things like state and local taxes and mortgage interest. But it also changed the estate tax law. So under the Tax Cuts and Jobs Act, the federal estate tax exclusion amount, that is how much you can pass at death without paying any estate tax, went up significantly to $11.4 million per person. So over $22 million for a married couple can be passed at death without payment of federal estate tax. And that number is tied to inflation. So it's gone up a bit. It's now at 11.58 million for 2020. Also important to know, I mentioned a married couple. That exclusion is portable. What portability means is that if some of that exclusion was not used at the first spouse's death, it remains available to the surviving spouse to use in his or her estate at the death of the second spouse to die. So that's important to know. A big part of estate planning used to be making sure that assets were titled evenly between the spouses so that no matter who died first, we used as much of the exclusion amount as we could. We don't have to worry about that so much anymore because the unused exclusion is automatically portable and usable by the surviving spouse. So that was a good change that came under the Tax Cuts and Jobs Act. Important to note, however, that these changes expire in 2026 unless Congress takes action to extend them. And when they expire, these rates will go back and the exclusion amount will go back to what it was in 2017, which was about $5.5 million. So you could pass about half as much beginning in 2026 as you could in an estate that of someone who died now. Now that's only if Congress doesn't take some action to extend it. So just remember that this law is set to expire in 2026. Finally, to our purpose today, important to note that while the Tax Cuts and Jobs Act took away the ability to take significant deductions under the income tax law, the unlimited charitable deduction against the estate tax remains in place. So any assets that you leave to charity at death pass without payment of estate tax. So that's an important component of estate planning, especially estate tax planning. So that's the Tax Cuts and Jobs Act, at least the parts that impact the estate tax. The Secure Act was passed at the end of 2019, and this was passed in response to Congress's recognition that many folks, especially baby boomers, simply had not saved enough for retirement. So they made some changes in the law to incentivize greater retirement savings. These were some of those changes. The maximum age for traditional IRA contributions was changed. Previously, you could not make a contribution to your IRA after age 70 and a half. That's no longer the case. Now you can continue to make contributions to your IRA account for your entire life, as long as you continue to be working and earning. So you can think of it as a death or retirement is now the time when IRA contributions can no longer be made. The Secure Act also increased the required age for beginning required minimum distributions from IRAs and 401ks and 403bs. Previously, it was age 70 and a half when you had to start taking money out of your IRA or your 401k according to a uniform table that's published by the IRS. Tells you what the minimum amount is you have to take out each year. And if you don't take out that minimum, there's a big penalty tax. So you don't want to forget to take out your minimum distribution. Well, now instead of age 70 and a half, it's gone up to age 72. So important to note that you don't have to start, unless you've already begun, you don't have to start taking out distributions from your IRA or 401k until age 72. You can take distributions sooner. If you're younger than 59 and a half, there'll be a penalty tax if you start taking them out that soon, unless you qualify for one of the exceptions to the rule. But after that age, generally Congress is happy to see you start taking some money out to support yourself in retirement, because remember, when money comes out of those retirement accounts, it's now taxable income. So that money's been growing tax deferred in those accounts. When it comes out, it finally gets taxed. But this Secure Act delayed the starting date for required minimum distributions until age 72. Another thing that the Secure Act did, though, was it changed the minimum distribution rules for beneficiaries. So there's really no longer a stretch IRA allowed for non-spouse beneficiaries, except for folks in a few exceptional categories, for example, folks who are disabled. It used to be that beneficiaries could stretch out distributions from inherited IRAs over their own life expectancies. That is no longer the case under the Secure Act. Now the money either needs to come out in a lump sum or needs to come out within 10 years of the account owner's death. That's not true for the spouse. The spouse still can roll over into a spousal IRA and delay distributions until he or she reaches their own required beginning date and take those out over their own life expectancy. But for other beneficiaries, that money now needs to come out within 10 years of the account holder's death. So that's a way to force that money out and make it taxable sooner. So that's not a change that a lot of people are happy about. It kind of took away a real estate and tax planning, I guess I should say income tax planning tool, because the stretch out IRA, that is allowing beneficiaries to take distributions over their own life expectancy, meant that you were delaying the taxation, the income taxation of those assets, because they're just coming out a little bit at a time every year, and they're only taxed as they come out. No longer do we have that ability to stretch. Interestingly, and we'll talk about this vehicle in a moment, there is a life income vehicle called a Charitable Remainder Trust that could help us get something that looks like a stretch IRA. And I'll be talking about the Charitable Remainder Trust in just a little bit. And Greg, if I forget to connect the dots again and come back to this, please do remind me. So other than the Secure Act, the other act that I do want to touch on is the CARES Act, and this is one that came in the wake of the coronavirus pandemic. It made some significant changes that impact us, especially during this calendar year 2020. The first thing the CARES Act did for our purposes today was, beginning this year in 2020, non-itemizers. So folks who are not itemizing their deductions, these are people who typically weren't taking a charitable deduction per se because they weren't itemizing. They were just taking the standard deduction. Beginning in 2020, those non-itemizers can claim a charitable deduction up to $300 for cash gifts to public charities. This is called an above the line deduction. So even though no deductions are being claimed, non-itemizers can indeed deduct up to $300 for cash gifts to public charities. And that begins just this year, this calendar year. The CARES Act also increased the AGI limitation, the adjusted gross income limitation for cash gifts to public charities. So previously, you could take a dollar for dollar income tax deduction for cash gifts given to public charities, but there was a ceiling, 60% of your adjusted gross income that year. And if you went over that, you'd have to roll or carry forward rather those deductions to the next tax year. And you could do that for up to 5 years. Well, for 2020 only, so important to note, we've got how many more months left in this year. This is nearly the end of September. So for the next 3 months, we have the ability to make cash gifts to public charities up and deduct them up to 100% of our adjusted gross income. And I have mentioned a couple of times, it's cash gifts and it's gifts to public charities. So it's direct gifts to those charities. It's not gifts to donor advised funds, to private foundations, and it's not gifts to fund things like charitable gift annuities or charitable remainder trust. These are outright gifts of cash to public charities, deductible to 100% of adjusted gross income. So that's only for 2020. Also, only for 2020, the CARES Act raised the cap on the deductibility of gifts made by corporations. It used to be that corporations could take a deduction for charitable gifts up to 10% of the corporation's taxable income. That's been raised to 25% of the corporation's taxable income. That's for 2020 only. And then finally, for 2020 only, the required minimum distribution has been repealed. And I don't know that this got enough publicity early on. My own dad was surprised by this. I'm glad that I told him before he had taken his required minimum distribution for 2020. But part of the CARES Act, again, this is in response to the coronavirus pandemic, was that folks don't have to take the required minimum distribution this year if they don't want it. And a lot of people don't like to take the required minimum distribution because, again, that's taxable income. And so they're trying to keep their taxable income down. Now that's a lot of changes under those 3 acts that have all happened in just the past couple of years. But you'll, of course, want to consult with your own tax advisor, your own CPA, your own attorney regarding your personal situation and any steps that you might want to take to in light of these changes. Greg, I'm going to move next to the section on gifts that provide retirement income, but I guess I'll just ask whether there are any questions that pertain to these,
Absolutely.
To these legal changes.
Yeah, so there are some questions about stretch IRAs and things of that nature, so I'm going to let that breathe until after we're done with the next session, I think, section. Okay. But I do have a couple of very good questions. One of which is one of our participants asked, how often should the documents be reviewed and updated for a family?
That's a great question. I think the rule of thumb for at least reviewing your documents and possibly updating them is whenever you had a significant life event, so you've moved to a different state, or you've gotten married, or you've gotten divorced, or you've retired, or maybe kids have been born. Those significant life changes are a time, or if someone passes away, if a spouse passes away, for example, those significant life changes are a time to review the estate plan documents and make sure they still make sense. In the absence of some significant life event, I'd say you want to take a look every 3 to 5 years. Maybe the older you are, the shorter that time period.
Right. second question, which I think is a good one as well, is if you retire at, say, ages 55 to 59 and a half, can you pull from one retirement account without the 10% penalty?
Yes, if you've separated from service, you should qualify for one of those exceptions to that 59.5 penalty tax.
Excellent. And we do have some poll opportunities, and so we'd like to flash a poll perhaps up as Tim transitions, and we'll seek your feedback on that to make this interactive. And we'll give you some feedback on those after we go through another section here.
So sure, I can start while folks take the poll. I'll just state again that the last part of today's remarks has to do with charitable giving, but specifically ways that you can give to ECU or to another charity of your choice that also generate additional income for you during retirement. And as I mentioned before, that was a popular topic among those who submitted questions during the RSVP period. So just thinking about retirement, I guess I may ask you, what do you think about when you picture retirement? And before I share my picture, I'll wait till the poll goes down. But many people are picturing things like travel, for example, or maybe engaging in a favorite hobby, a favorite sport. You know, here's folks that you may not be able to see them. There they are. These folks who wanted to travel during retirement. So for them, this was their ideal retirement. Here's another couple that they enjoy playing golf apparently together, and this is what they're doing during retirement. And of course, a lot of folks might like to do that during retirement or pursue a different hobby. And here's a quote that I found by Gene Parrott. I'll tell you about him in a moment. "I enjoy waking up and not having to go to work. So I do it 3 or 4 times a day." Gene Parrott's a funny guy. He was a writer for the Carol Burnett Show and Laugh-In and Welcome Back, Kotter and Three's Company. He was Bob Hope's head writer for some time. So there's a funny guy, but he's enjoying retirement in his way. But regardless of what you picture yourself doing in retirement, a key question is whether your retirement savings and your retirement income will permit you to do the kinds of things that you envision. And here's a quote from another noted philosopher, George Foreman, who said, "The question isn't at what age I want to retire, it's at what income." And he's right, because, you know, while retirement can conjure up those images of travel and fun, there can also be obviously a sense of worry that can appear. Gosh, have I set aside sufficient funds for my retirement? Do I have plans for other income that might come in during my retirement that'll let me do those things? And so what I'd like to do is spend a few minutes now looking at some ways that extra income can be generated during retirement in the context of a charitable gift, either to ECU or to another charity of your choice. And it's important to remember that, you know, part of this sense of concern about whether you have sufficient assets set aside for retirement is that we are living longer in retirement these days than we used to. So this is information that's taken from the Social Security Administration. But you can see that the life expectancy for someone at age 65 or 75 or 85 is greater now than it was in 1950, significantly, and is projected to get greater still as we move forward in time. So here we can see for someone who's age 65, for a male who's age 65, if that person were 65 in 1950, they were expected to live another 12.8 years. In 2010, a 65-year-old had a life expectancy of 17.5 years. That's a big jump. And by 2050, we expect that the life expectancy for a 65-year-old then will be 22 years. So it keeps going up. We're living longer in retirement. And for women, those life expectancies are even longer. The women, even back, in 1950 and before, had longer life expectancies than men at each age. You can see that is those numbers are converging a bit. It's getting closer and closer, but still the point is that, you know, a woman who is age 65 in 2010 still had a 20-year life expectancy. And if you're going to turn 65 in 2050, you'll have a 24-year life expectancy. So we're living longer in retirement. So planning for our income in retirement becomes more and more important. And as Greg knows and Greg's colleagues know, when they are working with folks who are considering a gift to support ECU or to support another charity, their philanthropy is not the only thing that's on their mind. And I mean, you know this personally. If you're considering a gift to charity, you're thinking about other things as well. Have I saved enough? What if you're taking care of someone else? Perhaps it's a parent who is in assisted living, and you're concerned that he or she has sufficient assets, and perhaps you'll be helping. We've seen a couple of bear markets in the last 20 years, and maybe you are worried about the volatility of the stock market, and you think, gosh, I'm not sure I can afford to give away some money now. What if we have another decline in the market? Or perhaps you're helping another family member, maybe someone who is still getting launched after college, and you're asking, gosh, how long will I be helping to support that person? And while that's a concern for me, maybe that makes me hesitate before I make a big charitable gift. So it's important, I think, that we all acknowledge that we've all got lots of different concerns going on besides our desire to support our favorite charities. And so I thought it'd be very helpful to just visit with some different techniques that can, in the context of a gift to charity, also generate a little income in retirement. Here's our menu. We're going to talk about deferred charitable gift annuities, retirement, as we call them, retirement flip unit trusts, and charitable remainder annuity trusts. Many of you are probably familiar with charitable gift annuities. You probably get mailings from a variety of organizations about those. Of course, that's essentially a simple contract where you contribute funds now, and in exchange, you receive a payment from charity for the rest of your life at a fixed dollar amount. That's a charitable gift annuity. A deferred charitable gift annuity is a particular type that we'll see could really benefit someone who is approaching retirement age. Unit trusts, what we're talking about here are charitable remainder unit trusts. That's a charitable trust where you contribute assets to that trust now, and under the terms of that trust, it pays you or someone else an income stream. It's a variable income stream. It goes up and down with the investment performance of the assets in the trust for life or for a term of years. And then at the end of that income stream, the balance passes to charity. Well, there is a particular type of charitable remainder unit trust that can work well for someone who is approaching retirement and is looking to generate some additional income. And then charitable remainder annuity trusts. They're kind of a combination of a charitable remainder trust and a gift annuity, in the sense that they also pay out a fixed dollar amount year after year, rather than one that goes up and down like a unit trust. So with that in mind, let's jump into to some examples. So this is Mark. Mark is 65 years old. He's still working. He's thinking of retiring in the next few years, next couple of years. And he says, I've done a pretty good job of setting aside money in my 401k, but the market goes up and down, and I'm a little bit worried about that volatility. I'd like to have a stable element to my retirement income. So for Mark, who again is still working, he could use a charitable deduction as well, an income tax deduction. For Mark, we might consider a deferred charitable gift annuity. We know that the gift annuity is that vehicle where you make a contribution now and it pays you or you and another person a fixed dollar amount year after year after year for the rest of your life. You get to take an income tax deduction now on funding, and after that fixed payment is finished, after the annuitant has deceased, the balance that's left then passes to charity. Well, Mark says, I don't really need extra income now. I'm still working. I could use the deduction. And Mark is happy to learn that there is something called a deferred charitable gift annuity, where he makes the gift now, takes the deduction now, but the payments don't start right away. They start at a future date that he specifies in the contract. And so he could specify that they begin 2 years from now or 3 years from now, whenever Mark has decided he wants to retire. And so this is something that makes a lot of sense for somebody in Mark's position. He could use the deduction now, and he wants to generate a fixed, stable stream of income when he retires. So that's the deferred charitable gift annuity. Once those payments start to Mark, they don't change. It's the same payment year after year, which is what he wanted. He's got plenty of money in his 401k. That'll go up and down, but he would like a stable income stream as well. Well, that's Mark at age 65. What if we take a look at somebody who's a little bit younger than Mark? And this is Steve. He's 60 years old. He's still working. He's also thinking, like Mark, that he could use a charitable deduction now, and he'd like some additional income in retirement. But Steve's not sure how long he's going to work. He's 60 now. Maybe he'll retire at 65. That's the earliest he might retire. But maybe he'll retire at 70, maybe even later than that. He's not sure yet. He hasn't made up his mind. So for Steve, we could consider something called the flexible deferred charitable gift annuity. So it's like Mark's deferred gift annuity in that the payments aren't going to start until the future. And Steve has said the soonest my payments will start is 5 years out, year 5. And at that age, Steve would get an annual payment of $5,500 a year if he funded this with $100,000. But maybe in year 5, Steve isn't ready to retire. He doesn't want the payments to start then. Well, under this contract, he has the flexibility to tell ECU or whatever charity has issued the gift annuity that I don't want to start my payments yet. He could wait another year. If he waits to year 6, his fixed payments, once they begin, are larger. Year 7, they're even larger if he waits until then, and so on. If he waits until 10 years out, his payments, once they begin, will be significantly larger, $7,000 in this example, and they don't change. It's a fixed payment because this is a charitable gift annuity. The benefit to Steve, the benefits were that he got to take a deduction now for setting up the gift annuity, and that he didn't have to turn on his payments at a certain time the way Mark did. Instead, Steve retained the flexibility under the contract to tell the charity when he wanted those payments to start. And the longer he waits, the larger rather the payments will be once they come to him. So this is a great plan, the flexible deferred gift annuity, when the future is a bit uncertain. Someone who knows they're approaching retirement but hasn't quite decided how soon they would like to retire. So this is a way for both Mark and Steve to generate a little extra income, fixed income, during retirement. Okay, so that's the deferred gift annuity. And we'll have time for questions about all of these things at the end. We'll save plenty of time. I'd like to move to the next vehicle, and we're going to look here at Janet. Janet is 62 years old, she's still working, and she's doing a great job saving. She maxes out her 401k contributions. In fact, she'd like to save more. She's concerned that she'll have enough money in retirement because she expects to live pretty long time. Her parents both live well into their 80s, and Janet is taking good care of her health, and she expects to have a long time in retirement. So when she retires in the next few years, she'd like to be able to generate an income tax charitable deduction now. She's still working, but she'd like her future income, not like Mark and Steve, where they said, I want a fixed payment. Janet says, I like the stock market. I like the idea that my income in retirement might go up, especially because I think I'm going to live a pretty long time. So I'd like my income to have the chance of increasing over time. So for Janet, we might look at what we call the retirement flip unit trust. You might be familiar with a charitable remainder unit trust, which is shown here, where Janet would contribute property. It could be appreciated securities, real estate, cash. She contributes that property into a trust. The terms of that trust say that it's going to pay Janet an income stream, either for a term of years or for her life. The way that income stream is calculated, it's not a flat dollar amount. Rather, it's a percentage of the value of the assets in the trust as we revalue that trust year after year. So on January 1st every year, we say how much are the assets in the trust worth now, and we multiply that by 5%, and that's how much Janet is going to receive for the next calendar year, and that continues every year. So of course her payments are going to go, they're going to fluctuate depending on how much the assets in the trust are worth. If they go up, her payments will increase. If the assets in the trust go down in value, her payments will decrease. And so it'll be a bumpier ride, but Janet is comfortable with that. She gets to take an income tax charitable deduction on setting up the unit trust. Why do we call this a flip unit trust? Because with a flip unit trust, the trust essentially leads two lives, one at a time. Initially, the trust starts out as what's called a net income unit trust. It's paying Janet the lesser of the net income earned, or the unit trust percentage. So if our trust is not earning very much income, and of course today we know interest rates are really low, so it's tough to earn very much income. During that initial period, Janet's not receiving anything or not very much from the trust, which is good with her because she's still working. She doesn't need additional income at this time. And once we cross what we call the triggering event, which is described in the trust instrument, the trust then flips the next January 1, and it stops being a net income trust. It becomes a standard unit trust where it starts paying out 5% of the value that's in the trust year after year. For Janet, she liked that flip to occur at the time she intends to retire. She doesn't want to receive income now, but when she retires, she'd love for this trust to flip and become a standard unit trust. The goal for Janet, one of the goals, is that during this pre-flip period, rather than paying out an income to her, that the trust assets are invested so that they go up in value, so that by the time the trust flips and becomes a standard unit trust, it's going to pay out 5% of something larger than she funded it with. That's the hope. That's one of her goals. So what are some concerns? And then of course, upon Janet's death, the balance that's in that trust passes to charity. So what are the concerns? What are the things to keep in mind? Well, as I explained before, that trust flips January 1 after the occurrence of what I called the trigger event. Trigger event is something that's outside of the control of the donor. Examples allowed by the tax code: the sale of an illiquid asset. So if this trust were funded with real estate, we could use the sale of the real estate as the trigger event. Or somebody's, birth, death, marriage, or divorce. That's considered, those are considered acceptable trigger events. However, in the case of a retirement flip unit trust like Janet's, what we're likely going to use as the trigger event is a fixed date. That fixed date is going to be spelled out in the trust instrument. That fixed date is going to be a date that Janet chose to coincide with when she plans to retire. So if she plans to retire 7 years from now, and this is 2020, she might say that the trigger event is a fixed date of December 31st, 2026, or December 31st, 2027. That means the next day, the next January 1st, the trust will flip and become a standard unit trust and start paying her out 5% of the market value of the trust. So that's in broad strokes, that's how the retirement flip works. I mentioned before that, one thing we're trying to do is, grow the assets in the trust during that pre-flip period so that it's bigger once the payments begin. And it's important to see that the shorter that pre-flip period is, the more variability we're going to see in the investment results. So this is a chart that shows returns from a 70-30 stock bond portfolio, sometimes called like a growth portfolio, 70% stocks, 30% bonds, from 1926 through 2019, using the S&P 500 index for stocks, and you can see at the bottom Ibbotson Associates U.S. Intermediate Government Bond Index and the U.S. Long Bond Index as the index for the bond portion of the portfolio. So we're trying to have a nice couple of indices here used for the stocks and the bonds performance over that time. But we're looking at returns from 1926 through 2019, and we're looking at the blue bars show the range of returns experienced during every 1-year period, every 5-year period, every 10-year period, 20 and 25-year period during that span of time. So for example, the 5-year periods would be the 5-year period of 1926 through 1930, then the 5-year period of 1927 through 1931, 1928 through 1932, and so on, each of those 5-year periods. So as you can see, if we look at the range of returns that occurred during every 1-year period, there was 1 year in that century of time where there was a 38% return. But there was also a year during that century of time where there was a negative 31% return. So if you got only a year in your pre-flip time period, my gosh, the range of possible returns based on history is quite broad. As the period of time you have to work with gets longer, the range of possible returns starts to tighten up. So if we look at every 10-year period in that period of time there from 1926 through 2019, every 10-year period, we can see that during the best 10-year period, it was a 16.5 return for that 10-year period, 16.5%. And the worst 10-year period between 1926 and 2019, there was a positive return. It was tiny, 1.8%. But if you look at every 10-year period, there's no 10-year period in which there was a negative return. We go out to 20 years and we see the range tightens again. The worst experience for any 20-year period was still 3.9% return, and so on. The lesson from this slide is that based on history, if you have a longer period of time to work with, the range of returns likely is going to compress, and you're going to have less of a chance of having a negative experience for that period of time. I hope that that's clear. I'd be happy to talk about that further when we get to the Q&A portion. But so what does that mean for somebody like Janet? Well, you know, let's say Janet's working with a 5-year pre-flip period. You know, we don't know what the stock market's going to do over the next 5 years, but let's just look at a couple of examples of what could happen for somebody like Janet. What if Janet sets up a $500,000 retirement unit trust, and she sets it up on January 1st of 2002, and the pre-flip period is going to be 5 years. So the triggering event is going to be December 31st, 5 years from the date of funding. Let's see what happens to the investment of the assets during that pre-flip period while we're trying to grow the assets in the trust. Well, it's $500,000 when Janet funds it. During that first year, it goes down a bit, but then the market really starts to do well. You know, beginning 2003 and the next 4 years, it grows and grows until at the end of her 5-year period, that $500,000 that she put in the trust is now worth over $800,000. And so her payment, 5% of $815,000, is going to be nearly $41,000 in that first year. That's a really good experience for Janet. That's what she hoped would happen when she set up this retirement flip unit trust. What if Janet had set up that exact same trust, but instead of January of 2002, she'd done it in January of 2004? Well, so now that's the sort of brown line here. You can see that, you know, during that first year, she has experience that looks a lot like the 2nd through 5th years of, or rather the 3rd through the next few years of the first trust, the January 2002 trust. But she started in January 2004, and so it starts doing really well. The trust grows. Over the first 2, 3, 4 years, it's grown quite a bit. Once we get 4 years out, you can see it's essentially at the same place as the 2002 trust. But what happens then? We get 4 years out from January 2004. As we all recall, there was a recession and a precipitous decline in the stock market, 2008, 2009 time period. And so the 5th year of this pre-flip period, Janet's trust investments, just like anybody else's investments that were in a 70-30 stock bond mix during that period of time, dropped like a rock. And so when she got 5 years out, instead of $500,000 that she'd funded the trust with, she only has $492,000. So her payment in that first year is going to be $24,000, 5% of $492,000. So identical trusts, the only difference, they were set up 2 years apart. And they had very similar pre-flip experiences for the first 4 years, but in that last year, there was a big drop. So this is something to keep in mind, that we invest prudently to try to achieve some growth in the assets prior to the flip, but it doesn't always work out because sometimes the stock market takes an unexpected drop, as it did during the Great Recession. Okay, the last example I want to look at before we get to Q&A, I'm calling it a bridge to retirement, and here the vehicle is the Charitable Remainder Annuity Trust. This is Anita, and she said, here's my dilemma. I want to participate in the campaign, but I retired early. She's a young person, but she's already retired. And she says, I'm living off of my assets now. I need the income from my assets because I don't want to start Social Security payments yet, and I certainly don't want to tap my retirement accounts until I have to. And remember, she doesn't have to start taking payments now until age 72. So she'd like to make a gift now, but she needs to generate a little income to help her get from where she is today to the start date of her retirement distributions and her Social Security. So what might work for somebody like Anita? Well, it's a Charitable Remainder Annuity Trust. So it's similar to the charitable trust that we saw Janet set up, except rather than paying a stream of income that fluctuates and goes up and down with the stock market, the annuity trust pays out the same dollar amount year after year after year. So it might be expressed as 5% of the funding assets, but whatever that dollar amount is locked in, and it will pay the same amount to Anita for the term of the trust. It's going to run for Anita's lifetime. She's going to do what's called a term of years trust. So it's going to pay out to her for a term of years, and that term of years will be however long it takes for Anita to get where she is now to where she intends to start taking out money from her retirement account and her Social Security. So if she's 10 years away from that, in the trust instrument, she'd specify that it's going to run for 10 years, but it's going to pay her a fixed dollar amount for that period of time. She likes it because, she's living on her investment income. She can use an income tax charitable deduction now, and she wants to participate in the campaign, so she can make the gift now to fund the CRAT, and it's going to pay her a fixed a dollar amount every year now to sort of bridge the time period between where she is right now to the time when her withdrawals from her retirement account and her Social Security begin. So that's a good vehicle for someone who's in Anita's situation. She doesn't like the idea of the variability of the stock market. She likes the idea of the fixed payments, but it's really important that Anita chooses the correct term of years to make that bridge happen, and that she chooses a payout rate in the trust that will accomplish her goals. If she needs to receive X dollars a year every year for the next 10 years, then that's what should be specified in the trust instrument. So I think what we've done in a pretty short amount of time is we've looked at some hypotheticals, but I hope they've helped you see how different individuals who want to support charity but also generate some extra retirement income can do it, but in a variety of ways that match their particular circumstances. Okay, Greg, that's the end of my prepared remarks, and let's see what questions and comments have come in.
Absolutely. So thank you, first of all, so much for sharing that information and the multiple different opportunities that are out there. I did want to go back around and see if Nicole could pull up our poll results just to see what people were thinking. And so, I think our group seems to be very connected to ECU. and from a variety of different areas, which we're so thankful for. Many people have started their estate planning process, and it looks like about 16% of people are very comfortable, 37% are comfortable, 32 neutral. So I think the timeliness of this topic as people are gaining comfort is just well timed, and based on the legislative updates and all the changes that have taken place, I think this was a great time for people to really think about and see some of the different options that are available for donors. So we certainly thank you. Before I get to questions, it corresponds with one question. We had a donor or a participant ask, this person actually happens to be both, how the Stretch IRA with the Secure Act, you referenced just talking a little bit about that, but the difference now for the Secure Act and Stretch IRA, how a charitable gift annuity, a testamentary charitable gift annuity, or a charitable remainder trust might be a great gift vehicle for someone.
Yeah, it's, as I mentioned, under the Secure Act, the ability to stretch distributions over the life expectancy of the beneficiary has been curtailed greatly. The money has to come out within 10 years. And so if you are someone who would like to use the assets in your retirement account to benefit charity, but also to provide a stream of income to a family member and have that pay out over their lifetime or over a period of years, rather than have it all forced out in a short amount of time, it is possible to name a charitable remainder trust or to name ECU to fund a charitable gift annuity on the beneficiary designation of that retirement plan account. So let's just use a charitable remainder trust as an example. If I set up a charitable remainder unit trust to benefit my child, and my child is, let's say, age 45, and has a nice long life expectancy, and that person would would have otherwise taken money from my retirement plan account over their life expectancy in small pieces. They can't do that anymore under the law. Instead of naming the child directly, I have the charitable remainder trust receive the assets from my retirement account. The charitable remainder trust is a tax-exempt entity. That means that no income tax is paid on those assets from my retirement account when they land in the trust. The trust now will start to pay out, let's say, a 5% payment every year to that beneficiary, which looks a lot like a stretch out IRA. They're getting a small percentage of the assets every year over their lifetime, or over a term of years, up to 20 years, if that makes more sense. It's ordinary income to that recipient when it comes out of the charitable remainder trust, but it was going to be ordinary income when it came out of the retirement account anyway. So it's a way to get that stretch, but also to benefit ECU or another charity as the remainder beneficiary when that income stream ends.
Excellent. Another question that I have received, and I've got some that were done before the actual presentation today, and we'll get to those, but another question was, what is the difference perhaps in a gift annuity and a charitable remainder trust? Each vehicle has sort of some benefits, I think, per the one you select.
Yeah, that is true. The big difference is just in the nature of the payment stream. They both generate an income tax charitable deduction on funding, and they both pay out an income stream either to the donor and someone else. They can both pay out for life. The difference is in the nature of the payment stream. With the gift annuity, the dollar amount payment never changes. It's the same year after year after year. And so if you're concerned about inflation, you might say, gosh, that $500 I'm getting from the gift annuity this year is going to be worth a lot less to me 20 years from now than it is today because of inflation. With the remainder trust, it's not a fixed payment amount. It's a payment amount that goes up and down with the performance in the stock market of the assets in the trust. So there's a possibility it can grow. That's the big difference. Other differences are that with the unit trust, you can have more than 2 income beneficiaries. you can make additions to a unit trust. So once the gift annuity is set up, you can't put more money into it. You just have to create a new gift annuity. But with a unit trust, you can make more gifts to it over time, take additional deductions, and increase the value of the assets in that trust. So you can add to a unit trust. Greg, I'm sure that ECU has policies about this where you're going to serve as trustee, but you can also name more than one remainder beneficiary in a unit trust. So whereas if a gift annuity were set up with ECU, ECU is going to get all the money that's left at the end of that gift annuity. But with a unit trust, you could structure it so let's say ECU is going to receive 51% of the remainder and a different charity will receive the balance. So I think those are the chief differences.
Absolutely. Another question has come in, and it says, under the CARES Act, may one donate $100,000 to one of the options you presented and deduct that amount this year as long as it is less than adjusted gross income? And I think I know the answer to that because it has to go to an outright charity, if I'm not mistaken, not a trust or donor advised fund, I think. Am I correct on that?
Right. No, yeah, you're right. That 100% of AGI limitation for 2020 applies to gifts of cash directly to a public charity. So not to a trust, not to a gift annuity, not to a donor advised fund, but just outright to the charity.
Absolutely. All right. So some of the pre-conference questions were, can we choose any state's 529 plan for grandchildren to designate in our estate plans, or does it depend on if they're going to college in a specific state?
Okay. That question gets at the fact that every state has at least one 529 plan, and these are college savings plans where you contribute the funds to the plan now. Hopefully the investments grow over time, and then when distributions are taken from that 529, as long as they're used to pay for educational expenses, there's no tax on the earnings inside of the plan as the money comes out. So it's a tax. It's a tax-free way, I guess, to use the earnings on that contribution to pay for college. And the terms of the plans vary a little bit state by state by state. Generally, Florida, I think, has a prohibition on anybody funding their 529 unless they're a Florida resident. But in most states, they don't care where you reside. They're happy to see your money go into their state's 529 plan. Sometimes there is a tax advantage to using your own state's plan. Where I live in Missouri, for example, we can take a state income tax deduction for money that we contribute to a Missouri 529, but then that's up to a certain ceiling, a pretty low ceiling. But other than that, generally you can contribute to any state's 529 plan and get the same results. I think I'd like to pass on a website for everybody to take a look at. It's called savingforcollege.com. Savingforcollege.com contains a zillion different things. The website's grown exponentially over the years, but one of the most valuable things it has is a state-by-state comparison tool. So you can see what the principal terms are of every state's 529 plan and how they compare against each other. You can even compare a list. You could create a list and it's free. You can compare a list of, I think, up to 10 different state plans and just see how they compare side by side and then pick. And I know a lot of people don't care about the state income tax deduction, or maybe that doesn't exist in your state. It doesn't in North Carolina. So what you're going to look at is, how have the investment returns been? That's probably what you're really concerned about.
Excellent. Another question is that they want, one of our participants wants to include a secondary beneficiary that lives in the UK and therefore does not have a social security number. Also, they may want to include a beneficiary that's a UK charity. What is the easiest way to try to go about international type of things of that nature?
So we do, from time to time see life income gifts that are set up to benefit someone who doesn't reside in the U.S. And our tax department then does research to see whether there's always a tax treaty, but they want to see what the terms are of the tax treaty between the United States and that country, because that tax treaty is going to say, for example, whether there are mandatory withholdings up to a certain amount to pay tax either in the US or in the home country, or whether taxes that are paid in one country are credited to the other. So it's going to depend on what the tax treaty says between those between the US and the country of residence of the other beneficiary. But you can do it.
Right. Perfect. We have a question that says, most funds in a 403B or a qualified retirement plan need to be transferred to an IRA before charitable giving to maximize tax savings. And so to add on to that question, why are IRAs and qualified retirement plans such an excellent asset for a donor to consider giving?
Okay, those are both great questions. I'm going to start with the second one first. Assets that are inside of any kind of retirement plan, whether it's an IRA or a 401k or a 403b, they're growing tax deferred. You're not paying any tax on the growth in those assets until the money comes out. When it comes out, it's taxable income. If you take that money out during life, that's taxable income to you. If somebody receives it after your death, like your children or your spouse, it's taxable income to them. Well, charities are income tax exempt. So if you're choosing between different assets to leave to charity and to leave to family, from an income tax perspective, you'd want to leave the retirement assets to charity, because charities like ECU are income tax exempt. And even though the money that comes out of that plan is taxable income, ECU is not going to pay any tax on it. So that's the answer to the second part of the question. The first part, I think, is getting at QCD gifts, IRA charitable rollover gifts. So we all know, I think, that starting 5 or 6 years ago now, it was made permanent that you can transfer money from a traditional IRA account or a Roth IRA, but usually it's the traditional IRA that makes sense. You can transfer, if you're over age 70 and a half, you can transfer money directly from a traditional IRA account to a public charity and not have that count as part of your taxable income. But it does go towards satisfying your required minimum distribution. That's the QCD, and there are some parameters. You've got to be over age 70 and a half. The maximum that you can transfer in any 1 year is $100,000. It's got to come from a traditional IRA or a Roth IRA, and it's got to go to a public charity. It can't go to a donor advised fund or a private foundation. It's got to go right to the public charity. And it can't be used to fund a life income gift like a remainder trust or a gift annuity. It's got to be an outright charitable gift. But the question was, do you need to transfer out of a 401k to the IRA to do that? Yes, you do. You can only make a QCD gift from an IRA. You can't get that one step, move the money directly from a 401k to charity. With a 401k, you take the distribution, it's taxable income to you. You're going to owe the tax on that. You can give the cash to a charity and you can take the deduction, but you can't get that nice, clean one-step gift unless the money's coming out of an IRA. So if you want to do a QCD gift, you got to get the money from the 401k to an IRA. That's a non-taxable trustee to trustee transfer. You can roll it over if the plan document permits. Just realize that it might take some time. So if this is something you want to get done in 2020, you should get on it now and not wait till the middle of December.
A question about, what do you think about the 3 to 4% withdrawal rule?
Not sure what.
I'm trying to figure out what that's in reference to.
I don't know if that's a kind of a rule of thumb for taking distributions. That almost looks like an endowment spending rate.
Yeah.
I can tell you that withdrawal rules with respect to retirement accounts are strictly governed by a uniform table that the IRS publishes. And that might start out as low as 3 or 4%, but it's going to go up as the person gets older. Under the uniform table, the percentage gets higher.
Right. Another question, just really about estate planning. When or is it beneficial to do a Roth IRA?
Yeah, Roth IRAs are great in that when the distributions are taken from the Roth IRA, there's no income tax owed on the income earned inside of the Roth IRA. If you've got money that's in a traditional IRA and you'd like to move it to the Roth, you uh, you can do that, but there is a waiting period. I think it's 5 years or so before the distributions are considered tax free, and you're going to have to pay the tax on the distribution from the traditional IRA. And so you got to ask yourself, how young am I? Is the tax hit of moving the money out of the traditional IRA going to be offset by the tax savings of the later distribution tax free from the Roth?
Right.
That's a good, that's a good CPA financial advisor, question. Get out the calculator and work with the right assumptions and tell you.
Right. Just to add to that, there are also some thresholds in terms of what your income is, whether you qualify for an IRA on the front end, and then of course, as Tim referenced, trying to move them from traditional to Roth, there is some tax consequence there. So
right.
But I think the main takeaway is talk with your accountant and financial planners on that end. Another question is, and I'll handle this one, Tim, is ECU's the beneficiary of our estate. Can ECU also be the executor of our will? And I'd love to take that question offline personally with the individual, but I did want them to know I got it. Also, there are instances where the vast majority of the estate comes. We would hire someone to distribute the estate to protect the university. And so there's some steps, but there might be a way to work that out. But regardless, we can suggest some options for a donor in that instance. Tim, I think we have really exhausted most of our questions here. A few were related to, again, earning income, and your presentation really did a great job of showing that there are multiple options to do that. I would point out that our relationship through the North Carolina Gift Planning LLC and with TIAA Kaspick gives us great rates to do in terms of basis points to set up a vehicle like that, which is hugely beneficial to the donor and to the university, because the payout will be greater for the donor and the remainder amount will be greater long term. So that shared relationship really is something that's beneficial to us, and we are glad to put together any type of illustrations for anyone of interest, seeing how that might work and play out from a tax standpoint. We have all that capability and would love to discuss those further. Tim, I'd just like to really say thank you again for your valuable time and expertise that you shared with our alumni and friends today. And so thank you for that. And also I'd like to thank everyone who has attended today for your valuable time and interest. We are so thankful for your passion for ECU, and we continue to hopefully add value regarding legislative updates and estate planning techniques that will help you and your family. Ultimately, our goal is to aid you long-term in your family long-term planning and your philanthropic objectives. So thank you so much for attending today, and thanks for sharing your vast information with us, Tim, and your expertise.
My pleasure, Greg. Always happy to support ECU. Go Pirates.
Go Pirates.
Thank you, everybody, for attending, and this wraps up our session. Thanks for all the great questions. I've put a few links in the chat box for all of our attendees today, and so check out more virtual events and the ECU Plan Giving website if you wish to leave a legacy at ECU or wish to download some helpful handouts and a wills guide, perhaps. A lot of people find those resources valuable. Anyway, thanks again. Stay healthy and safe, and go Pirates. And we hope to be in touch with you soon. Thank you.